Good morning. This is Rajeshkumar. Today we are going to analyze one problem question on accessories and Abettors Act 1861. The video content has been made available for informational and educational purpose only. Kindly go through the slides completely. Let's move on to the problem question. Aaron, Ethel's boyfriend, asked Ethel to supply him with a precise floor plan of her apartment. Ethel believes this is because he intends to burgle Sert's apartment, which is in the same block as Ethel and has an identical floor plan. Ethel does so, not caring whether or not Sert is burgled. Aran, however, used the information provided to break into a different apartment owned by Charles, where Aaron shoots Charles dead. Peter, knowing that Vicky will not consent, resolved to have intercourse with Vicky. He asked Ada, her roommate, to be absent from the room so as to facilitate the rape. Ada complies, assuming Vicky to be a willing partner. Igor asks Alika, a gunsmith, for a replica gun which looks as authentic as possible. Alika believes it is to be used to hold up a bank, but she sells Igor the gun anyway. In fact, Igor modifies the gun so that it is capable of firing bullets. He kills Imran, a counter assistant, in a bank with it. Dolly and the Mick are engaged in a bank robbery. Unknown to them, call an off duty police officer, run towards them, intending to make an arrest. Dave, another customer, mistakenly believing Carol to be another robber, intentionally trips Carl's up, thus facilitating Jolly's and Mick's escape. Consider the possible liability as an accomplice of Ethel, Ada, Aliska, and Dave to any crime which may have been committed by Aaron, Peter, Igor, and Dolly and Mick. To determine the liability of Ethel, Ada, Elisa, and Dave as accomplices, it is necessary to apply these legal principles of accessorial liability under the Accessories and Abettors Act 1861 and the relevant case laws. Accomplice liability requires proof of actus reus, that is, assistance or encouragement, and the mens rea, the intent to assist or encourage the principal offender in the commission of the offense. Let's start with Ethel's liability as an accomplice in the murder committed by Aaron. Ethel provided Aaron with a floor plan of her apartment, believing he intended to burgle a Sert's apartment. Aaron instead burgled Charles' apartment and killed Charles. Under R versus Bainbridge 1960 case, Ethel's liability as an accomplice hinges on whether she intentionally assisted or encouraged Aaron to commit the burglary, and whether her assistant was sufficiently connected to the eventual crime. While Ethel knew the floor plan might be used for a burglary, she did not intend or foresee occurring, nor did she know Aaron's precise target. Applying the principle in R versus Jogi in 2016 case, Ethel's indifference does not establish the requisite mens rea for murder, as she did not intend to encourage or assist the killing of Charles. However, she may be liable for aiding the burglary under the Section 9 of the Theft Act 1968 if the floor plan substantially facilitated Aaron's entry into the Charles apartments. So, in other words, in this case, the principal offender is murder committed by Aaron when he shoots Charles. To determine whether Ethel could be liable as an accomplice, we must first examine the requirement of the mens rea for accomplice liability. According to R. vs. Johnson in 1976 case, an accessories must have the necessary mens rea regarding both the act of assistance and the offense that was ultimately committed. Ethel provided Aaron with the floor plan of an apartment, but she did so with the belief that the information would be used to commit a burglary at Sir's apartment, not to commit the murder. Therefore, Ethel did not have the mens rea for murder, as she neither intended nor foresaw that Aaron would kill anyone. Under R versus the Maxwell case in 1978, the liability of an accessory is limited to what they intended or foresee as the likely consequences of their actions. Here, Ethel was not aware of Aaron's intent to commit murder, nor was it foreseeable to her that the floor plan would lead to a fatal outcome. As Johnson versus Uden case 1950 emphasizes, and accessories must be aware of the basic facts that constitute the principal offense. In this case, since Ethel did not know or foresee the murder, she cannot be complicit in the killing of Charles. Therefore, Ethel cannot be liable as an accomplice to the murder. The second scenario adds liability as an acceptance to the rape committed by Peter. Ada's compliance with Peter's request to leave the room facilitated the Peter's planned rape of Vicky. However, Ada believed Vicky to be a willing participant. The case of National Coal Board versus Gamble in 1959 case emphasized that accomplice liability requires both assistance and the intent to assist the principal offender in committing the crime. Here, Arrow's lack of awareness of Peter's criminal intent precludes the mens rea for accomplice liability. Following R versus Bryce case in 2004, mere assistance without knowledge of the principal's criminal purpose is insufficient. Thus, Ada would not be liable as an accomplice. In other words, in this case, Peter commits the rape of Vicky, knowing that Vicky will not consent. Ada, by leaving the room, facilitate the crime under the false assumption that Vicky is a willing partner. For Ada to be liable as an accomplice, she must have the mens rea for the offense and know the basic fact of the crime being committed as established in R versus Johnson case in 1976. The adder's action of leaving the room may be seen as an assisting Peter, but she did so under the mistaken belief that Vicky consented to the act. Given that Ada did not know Vicky would not consent, she cannot be held complicit in the rape. The mens rea for the rape includes the knowledge of the lack of consent, as outlined in R versus Cunningham case in 1957, where the defendant must intend to have the intercourse without consent. Since Ada was unaware of the Vicky's lack of consent, she cannot be liable as an accomplice to the rape. Her actions, while facilitating the crime, do not meet the threshold for accomplice liability due to the lack of mens rea. Alika's liability as an accomplice to murder committed by Igor. The Alisa sold Igor a replica gun, suspecting he intended to use it for the bank robbery. Igor modified the gun and used it to kill Imran. Under R vs. Johnson and Jordan case in 1950, accomplice liability requires knowledge of the essential elements of the principal crime. While Alika suspected illegal use, she did not know Igor intended to modify the gun into a lethal weapon or commit the murder. The principle in West R versus Bainbridge case in 1960 suggests Alicia may be liable for aiding the robbery if a suspicion of Igor's intent suffices to establish the recklessness. However, she cannot be liable for murder unless it can be shown that she foresaw a real possibility of lethal use as outlined in Orr versus Jogi case in 2016. In other words, Alisa sells Vigo a replica gun knowing that it is to be used for a bank robbery. However, Igor modifies the gun and it is later used to kill Imran in the bank. Ali's liability as an accomplice is based on what crime she knew or believed Igor intended to commit. Under R versus Bryce case in 2004, an accomplice is only liable for the crimes they know or foresee as likely to occur. In this case, Alika knew the gun was intended for the bank robbery, but there is no indication that she knew Igor intended to use the gun to kill anyone. As R versus Maxwell case in 1978 established, accomplice liability extends only to the crimes the accomplice contemplates. Since Alika only knew that Igor intended to use the gun for robbery, she cannot be liable for murder. Alika's liability would be limited to the manslaughter if it could be shown that she knew the gun could be used in a dangerous manner, that is, for example, in a bank robbery, but did not foresee that it would be used to kill someone. R versus Bristow case in 2017 highlights that an accomplice could be liable for the manslaughter if they are aware of the dangerous nature of the weapon used. But it is unlikely Alika could be found complicit in the murder as murderer because the foresight of the potential of for the serious harm or the death which was not contemplated by Alika. Dave's liability as an accomplice to the robbery committed by Jolly and the Mick. Dave's intentionally tripped Carol, mistakenly believing her to be the fellow robber. This facilitated Dolly's and Mick's escape. The liability hinges on whether the Dave's act assisted the principal offenders and whether he intended to assist in the commission of the crime. Under Orr versus Clarkson in 1971, mere presence or an accidental assistance does not constitute accomplice liability. However, Dave's intentional act of tripping the Carol facilitated the robbery. Although his belief was mistaken, his intent to aid what he thought was a robbery satisfied the mens rea for accomplice liability. Dave could be liable for aiding and abetting the Dolly and Mick under the Section 8 of the Accessories and Abettors Act 1861. In other words, Dave unintentionally assists in the escape of Dolly and Mick who are engaged in a bank robbery. The key question is whether Dave could be accomplice to the robbery. For accomplice liability, there must be both actor-stress, assistant or encouragement, and mens rea, the knowledge or the intent to assist in the commission of the crime, as established in Orr versus Johnson case in 1976. Dave's action at tripling the Carol and off-duty police officer were done mistakenly under the belief that Carol was another robber. Since Dave did not know that Carol was a police officer and did not intend to assist in the robbery, his actions do not meet the mens rea requirement for accomplice liability, as or versus Saunders and Alker case in 1992 suggests accomplice liability requires that the defendant have the requisite intent or the knowledge about the principal crime. In this case, Dave's actions although facilitating the escape, were done without the knowledge of the robbery, and he did not intend to assist or encourage it. Therefore, Dev cannot be held liable as an accomplice to the robbery. To conclude, the accomplice liability of each individual is dependent on their mens rea and actus reus. Ethel cannot be liable for the murder because she did not foresee or intend to kill him. Ada cannot be liable for the rape as she did not know about Vicky's lack of consent. Alika's liability is limited to the possible manslaughter as she did not foresee the use of the gun to commit the murder. Lastly, the Dave cannot be liable for accomplice liability to the robbery as he did not intend to assist or encourage the crime. The analysis hinges on whether each accomplice had the necessary knowledge or the intention to assist in the principal crime as reflected in R versus Johnson and R versus Maxwell case. In other words, Ethel, the potential liability for aiding the burglary but not for the murder, as she lacked the intent or the foresight of the killing. Second category, A. Ada, the no liability as she lacked knowledge of the Peter's criminal intent. Alisa, the potential liability for aiding the robbery but not for the murder unless it can be shown she foresaw Ego's lethal intent. Dave case liable for aiding and abetting the robbery due to his intentional act of assistance despite his mistaken belief about the call. Thank you.